Your carry setup could be perfectly legal today and still get you charged tomorrow because of one court ruling, one missed renewal rule, or one bad state line crossing. And if you think your permit alone protects you everywhere, that belief could fail you at the worst possible moment. Pause. Quick question before we continue. Are you subscribed? Because what I'm about to reveal could save you from a brutal legal mistake. Hit that button now because these changes are either already rolling out, waiting on judges, or sitting in Congress right now. Today, I'm breaking down 7 carry law changes that could hit concealed carry holders hard. Some may help you, some may trap you. And one of them could decide whether walking into a store with your handgun is self-defense or a crime. scotusblogcongress.gov, California Department of Justice. First thing, the biggest change may not come from your state at all. It could come from the Supreme Court. The case is called Wolford v. Lopez, and it targets a Hawaii law that says permit holders cannot carry on private property open to the public unless the owner clearly says yes. Think about what that means in real life. You pull into a gas station, you stop at a corner store, you walk into a shop at the mall. Most people assume if the owner did not post a sign, they're probably fine. But this case is about the exact opposite idea. Silence could mean no. That is the part that shocked me. According to the case coverage, breaking that Hawaii law can mean a misdemeanor and up to a year in prison, and Hawaii is not alone. California, Maryland, New York, and New Jersey have similar laws on the books. Now here's the crazy part. The challengers say this kind of rule makes normal public carry almost impossible because most daily life happens on private property open to the public. A decision is expected by summer, so this is not some far-off theory. If the court backs Hawaii, more states may feel safer using default no-carry rules. If the court strikes it down, permit holders in several states could get major relief. Either way, if you carry in one of those states, this is the case to watch. SCOTUS blog, SCOTUS blog. Second, Congress still has a live reciprocity fight on the table, and yes, it could change interstate carry if it ever becomes law. H.R. 38 in the House and S. 65 in the Senate would let a person who can lawfully carry in his or her home state carry in another state that allows concealed carry. But here's what most people get wrong. Even under the House bill text, this would not erase every local rule. You would still need photo ID and either a valid permit or legal eligibility to carry in your home state. The bill also says states can still let private property owners ban firearms, and states can still restrict guns on state or local government property. So even if reciprocity passes, that does not mean carry anywhere. It means you would have a federal framework for crossing state lines, but you would still need to know the local off-limits places. As of the official pages, the House bill was placed on the Union calendar, while the Senate version was referred to judiciary. Translation in plain English: this is alive, but it is not law yet. Don't travel like it already passed. Congress.gov, Congress.gov, Congress.gov. Third, there is an even bigger federal idea now being pushed, and it goes beyond reciprocity. The National Constitutional Carry Act was introduced in the House as H.R. 645, and Senator Mike Lee announced a Senate version in March 2026. Lee said the goal is permitless carry nationwide for law-abiding Americans. Now, this is where it gets interesting. Reciprocity says, your state's carry status may travel with you. Constitutional carry at the federal level says you should not need a permit at all, and that is a huge difference. But wait, there's something even more important. Right now, this is still proposed legislation, not a rule you can rely on in public. The House page still shows introduced status. So if you live in a permit state, do not stop renewing, do not stop training, and do not assume Congress will rescue you before your next traffic stop. A lot of gun owners hear a headline and act like the law already changed. That mistake can ruin your year. Congress.gov, Senator Mike Lee. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when cops ask about your gun. Subscribe so you don't miss it. Fourth, Colorado quietly made concealed handgun permits harder to get and easier to mess up if you wait too long. Under House Bill 24-1174, any permit application submitted on or after July 1st, 2025 has to follow new rules. Training now must be taught in person by a verified instructor. No internet class. New applicants need at least 8 hours of training. Renewal applicants need at least 2 hours. There is now a written test with a minimum score of 80%, plus live fire training, and a test requiring 70% accuracy for both new and renewal applicants. Let me break this down for you. A lot of people think renewals are easy. They assume they can just file paperwork and move on. Not anymore. If you currently hold a Colorado permit, after July 1st, 2025, you generally need a refresher class from a verified instructor unless you fall into one of the listed exceptions, like certain retired law enforcement, retired military, or organized shooting competitors. And timing matters. Colorado says you can only renew up to 120 days before your permit expires. Here's a hypothetical example to explain this. Let's say your permit expires in 4.5 months and you wait because you think you still have plenty of time. Then you realize your old instructor is not on the verified list. The class you wanted is full, and your certificate window is running tight. That is how lawful carriers become expired carriers. This is one of those changes that does not sound dramatic on paper, but in the real world, it can leave you disarmed or non-compliant fast. Larimer County Sheriff's Office. Fifth, California made one of the most surprising carry moves in the country, and almost nobody is talking about it. Under AB 1078, effective January 1st, 2026, California licensing authorities must issue CCW licenses to non-California residents who meet certain requirements. Read that again. Non-resident permits in California. For years, many gun owners treated California as a dead end for carry. Now, this does not mean the state became easy. It does mean the door is no longer fully shut. If you travel into California for work, family, or extended stays, this matters. But here's the part nobody's talking about. The state also tied that change to more rules, more review, and more ways to get denied if your paperwork is sloppy. So, yes, one door opened, but several traps stayed right beside it. California Department of Justice. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Sixth, that same California law also got stricter about who can keep a carry license and how renewals must be handled. The bulletin says a licensing authority shall not issue a CCW and shall revoke one if the person knowingly gives inaccurate or incomplete information. It also adds another disqualifier, being an unlawful user of or addicted to a controlled substance. On top of that, the review of the protective order system must include whether the applicant is reasonably likely to be a danger to self, others, or the community. And for renewal applications filed before September 1st, 2026, the agency has to give written notice of approval or denial within 120 days. That sounds dry, but it matters. Imagine you rush your renewal, forget an arrest, leave out a detail, or assume a minor issue is no big deal. In California, that is not just a paperwork problem anymore. It can become a denial or revocation problem. The same bulletin also says a person may possess an unloaded firearm on a bus, train, or other public transportation property if it is locked in a lockbox. So if you carry daily, but must disarm before entering certain transit environments, transport rules matter just as much as carry rules. Most people focus only on the holster part. Smart people focus on the whole trip. California Department of Justice. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners who want these updates first. Click subscribe. Seventh, Massachusetts is another state where the changes are not just about getting a license. They're about keeping your routine from turning into a criminal mistake. The state's modernized firearms law already expanded off-limits areas, including government buildings, courts, polling places, early voting sites, and areas used for ballot storage or tabulation. It also tightened vehicle rules. If you have a large capacity firearm in a vehicle, the update says it must be unloaded and secured in a locked container. And no, the guidance says a locked vehicle by itself does not count. It has to be a locked glove box, locked console, locked trunk, or similar locked container. But here's the deadline concealed carry holders need to watch in 2026. Massachusetts guidance says licensing authorities can keep accepting certificates under the old training setup only until April 2nd, 2026, when Section 74 takes effect. The state is working on new basic firearms safety curriculum rules, and people who applied after August 2024, but before the law took effect, may still face the new course and live fire requirement at renewal. So if you are in Massachusetts, or you are a non-resident who travels through it, do not think this is just some paperwork story. This is about where you can carry, how you store in a vehicle, and what training may hit you at renewal. That combination catches people off guard because none of it feels urgent until the day your permit is on the line. MassGov, MassGov, MassGov. So what is the real takeaway from these 7 changes? Number 1, a Supreme Court ruling could reshape carry on private property open to the public. Number 2, federal reciprocity is alive, but not law. Number 3, nationwide permitless carry is being pushed, but it is still just a bill. Number 4, Colorado made renewals and training more demanding. Number 5, California opened a path for some non-residents. Number 6, California also made denial and revocation issues more serious. And number 7, Massachusetts tightened both training rollout and place-based restrictions. Have you noticed the pattern? Almost every change sounds simple in a headline, but the fine print is where good people get burned. Most people think carry law is about one question. Can I carry? The truth is, it is really 4 questions. Can you carry there? Can you carry that way? Can you renew on time? And can you prove you followed the rules when somebody asks? SCOTUSblogcongress.gov. California. Department of Justice, Larimer County Sheriff's Office, mass.gov. This information could literally expire after the next court ruling or the next state deadline. Subscribe now because the next video explains exactly what you need to check before you cross a state line, renew a permit, or walk into a so-called sensitive place. At the end of the day, your biggest threat may not be a bad guy. It may be bad information. If you carry concealed, you cannot afford to live on old advice, gun counter rumors, or headlines from 6 months ago. Pause. So, subscribe, stay sharp, and send this video to one friend who carries and thinks his permit works like a magic shield. It doesn't. Laws change fast, and every state plays by its own rules. Final, simple disclaimer. This video is for education only, not personal legal advice. Before you act, check your state law and talk to a qualified attorney if your situation is specific or urgent.